right now, somewhere in this country, and I mean right now, today, a landlord is doing something that is completely illegal, and the tenant living there has absolutely no idea. It might be entering your home without giving any notice at all, keeping your deposit without any legitimate reason to do so, or threatening to evict you without following any part of the proper legal process. Here's the thing. Most tenants never challenge any of this, not because they agree with it, but because nobody ever told them what the law actually says. Starting today, that changes. Welcome to the Scribe of Law. In this video, I'm going to walk you through the 4 areas where landlord-tenant law matters most: entry rights, security deposits, repairs, and eviction. By the end of this video, you will know exactly where the legal line sits and what to do the moment a landlord crosses it. One important note before we begin: laws vary, sometimes significantly, by country, by state, and even by city. I will cover the core legal principles that apply across the United States, the United Kingdom, Canada, and Australia, and flag where the key differences matter most. Section 1. Entry rights. This is the area that surprises most tenants, and with very good reason. The moment you sign a lease and move in, that property becomes your home, not your landlord's investment. Your home. And the law treats it exactly that way. In almost every jurisdiction in the world, a landlord must give you advance written notice before entering your home. In the United States and Canada, that is typically 24 to 48 hours. In England and Wales, the minimum is 24 hours. In Australia, it ranges from 24 to 48 hours, depending on which state you are in. That notice must also be for a legitimate and specific reason. Scheduled repairs, valid. A property inspection agreed in advance, valid. Showing the property to prospective tenants, also valid. But a landlord simply wanting to come in and look around, with no clear purpose, that is not a valid reason. And here is the part most tenants simply do not know. Emergency entry is the one genuine exception to this rule. If there is a flood, a serious gas leak, or a fire, a landlord may enter without notice to prevent serious damage or harm. But note that word carefully: emergency. A dripping tap is not an emergency. A squeaky door is not an emergency. If your landlord enters your home without proper notice and without your permission, that is, in most cases, an unlawful entry. You have the right to document it, write formally to your landlord, and in serious cases, report it to your local housing authority, or take legal action. Section 2. Security deposits. This is the area where more landlord-tenant disputes end up than any other single issue. Significant sums of money are lost every year by tenants, not because the landlord was right, but simply because the tenant did not know the rules that applied to them. First, how much can a landlord legally charge as a security deposit? This is capped by law in most countries. In England, the maximum is 5 weeks' rent for most tenancies. In most United States states, the cap is 1 to 2 months' rent. In Australia, it is typically 4 weeks' rent. In Canada, it varies by province. In Ontario, for example, the cap is 1 month's rent. Second, what can a landlord actually deduct from your deposit at the end of a tenancy? There is a clear legal answer. Landlords can deduct for genuine damage that you caused: broken fixtures, carpets stained by pet accidents, holes in the walls. What they cannot deduct for is normal wear and tear. These are 2 entirely different things in law. And here is exactly where the legal line sits between them. Most jurisdictions require the landlord to return your deposit or provide a fully itemized list of any deductions within a specific legal deadline. In England, that is 10 days from the moment you formally request it. In most United States states, the window is 14 to 30 days. In Australia, it is generally 14 days. Miss that deadline? In many places, the landlord legally loses the right to make any deductions at all. The single most effective thing you can do to protect your deposit before anything goes wrong is this. Take a time-stamped video of every single room in the property, every wall, every floor, every fixture, every appliance. Do it on the day you move in, and then again on the day you move out. That video is your evidence, if any dispute arises. Section 3. Repairs and habitability. There is a legal concept that exists in almost every jurisdiction, and it is called the implied warranty of habitability. In plain language, this means that regardless of what your lease says, your landlord has a non-negotiable legal duty to keep your home safe and livable. If your heating breaks in the middle of January, your roof begins to leak, or you discover a rodent infestation in the property, your landlord has a legal obligation to fix it within a reasonable period of time. What counts as reasonable depends on the severity of the issue. A broken boiler in the middle of winter is urgent. The expected response is often within 24 hours. A cracked window pane, on the other hand, is non-urgent. 1 to 2 weeks is typically considered acceptable. So, what exactly is the tenant responsible for? Day-to-day maintenance. That means replacing light bulbs, keeping the property reasonably clean, and not damaging the fixtures or fittings. The principle is straightforward. If you break something, you are responsible for fixing it or covering the cost. But if the structure of the property fails through normal everyday use, that is the landlord's legal obligation, not yours. If your landlord refuses to carry out necessary repairs after you have reported the issue to them in writing, you do have legal options. These typically fall into 3 main routes. First, report the issue to your local council or housing authority. Second, apply to a housing tribunal or tenancy court. And third, in some jurisdictions, you may be able to withhold rent into a legal escrow account until the repairs are completed. 1. Critical warning on that last point. Never withhold rent without taking proper legal advice first. Done incorrectly, it can seriously backfire. Section 4. Eviction. This is the area where illegal landlord behavior tends to be most serious, and it is also the area where your legal rights are at their absolute strongest. A landlord cannot simply tell you to leave. There is a specific legal process that must be followed, and if they skip any part of that process, the eviction is unlawful. In England and Wales, the 2 main eviction routes are the Section 21, a no-fault eviction, requiring at least 2 months' notice, and the Section 8, which requires a specific legal ground, such as significant rent arrears. In the United States, the required notice period depends on the state, and the reason for eviction, typically ranging from 3 to 60 days. In all cases, and in every jurisdiction covered by this channel, a court order is always required before a landlord can physically remove a tenant from the property. Now here is what a landlord absolutely cannot do, and I want you to pay close attention to this section, because this is where the most serious illegal behavior occurs. They cannot change the locks on your property while you are out. They cannot remove your belongings from the property. They cannot cut off your electricity, your heating, or your water supply in order to force you to leave. They cannot threaten you, intimidate you, or harass you in any form. Every single one of these actions is illegal. In many cases, they are criminal offenses, and crucially, they remain illegal, regardless of whether you owe any rent at all. If a landlord does any of those things, an illegal eviction has occurred, and you have clear legal rights as a result. You retain the right to re-enter your property. You are still the legal tenant. You can contact the police, as this is a criminal matter. You can apply to court, for emergency reinstatement of your tenancy. And in many cases, you may be entitled to significant financial compensation. So, what do you actually do if your landlord crosses one of these lines? Here is the process in order. Step 1. Document absolutely everything. Every time a landlord enters your home without proper notice, write it down with the exact date and time. Every repair request that goes ignored, write it down. Every threat or act of harassment, document it immediately. Take photographs wherever possible. Save every text message and every email. This documentation is your evidence if you ever need to make a formal complaint or take the matter before a court. Step 2. Put everything in writing. Send a formal letter or email to your landlord clearly outlining what they have done, what you require them to do to rectify it, and the specific deadline by which you expect them to act. Keep a copy of every communication you send or receive. A written record changes the legal dynamics of a dispute entirely. Step 3. Contact your local authority or the relevant housing body in your area. In England, that is your local council's housing team. In the United States, it is your state's housing authority. In Australia, contact your state's tenancy tribunal. And in Canada, reach your provincial landlord and tenant board. These bodies have real powers. They can investigate complaints, issue formal warnings, and in serious cases, prosecute landlords directly. Step 4. And this matters. Get proper legal advice. In many countries, free legal aid services, tenants unions, and law clinics exist, specifically to help people in your situation. You do not need to pay for a lawyer to understand and enforce your basic rights. Links to relevant resources are in the description below. Let us bring all of this together. Your landlord must give you advance written notice before entering your home, typically 24 to 48 hours. They can only deduct from your security deposit for genuine damage you caused, not for normal wear and tear, and they must return it within the legal deadline. They are legally required to keep your property habitable, working heating, a sound structure, and basic safety. And they cannot evict you without following the full legal process, which in every case ends with a court order. These are not suggestions. They are the law. The one thing I want you to do, directly after watching this video, go and check your tenancy agreement. Find the section on entry rights, the section covering your deposit, and the section on repairs. You now know what each of those sections should contain, and you know what the law requires of your landlord, whether it appears in that document or not. If this video was useful to you, and I believe it was, please share it with someone you know who rents. They need to know this. See you in the next one.